This is a fairly specific issue in relation to councils issuing certificates of discharge and exemption, so people will have certainty as to whether or not liability arises for second homes, non-principal private residence, specifically in relation to derelict property. So they will issue it when a sale goes through, but people who might have the view that they are exempt from it, the council could take an alternate view, and as the Minister is well aware, there are severe penalties for people who don't pay the NPPR, and as a result there could be huge, not only the fines, but the charge itself, but as well as back taxes. And I'm just wondering, in relation to this issue, is there any hope? I know that the tax is being removed, but if you didn't pay it over the last number of years, it's adding up every month, and if someone sells it in 10 years' time, of the belief that they're exempt, that there is no certainty, and there's no ability for them to get that certainty unless they actually sell the property, by which time obviously it's far too late if the council are of the view that they are liable for the charge. Thank you, Minister.
The Local Government Act 2009 broadened the revenue base of local authorities by introducing a charge on non-principal private residences. The charge was set at €200, and liability for it has fallen in the main on owners of rental, holiday and vacant properties. The charge has operated on a self-assessment basis, and 2013 is the final year of operation of the charge. The 2009 Act places the charge under the care and management of the local authorities, and application in particular circumstances is a matter for the relevant local authority. The interpretation of the legislation may be a matter for legal advice in individual cases, and ultimately may be a matter to be decided by the courts. Under the 2009 Act as amended, residential property is defined as a building that is situated in the state and that is occupied or suitable for occupation as a separate dwelling. As such, a property which is not suitable for occupation does not fall within the definition of residential property and is not therefore liable for the charge. There are a number of indicators as to what makes a property suitable for occupation for the purposes of determining liability to the charge. The indicators include the structure of the property, whether or not it has a roof, whether or not it is so affected by dampness as to render it unsuitable for habitation, and whether or not it has sanitary facilities including a water closet and water supply. It should be noted that certificates of exemption and certificates of discharge are issued solely in respect of residential properties as defined by the Act. Therefore, a local authority is not in a position to issue a certificate of discharge in respect of a property which is derelict, such that it is deemed to be uninhabitable on a given liability date for the charge. Should there be uncertainty as to the potential liability of a property to the charge, the owner is advised to contact the relevant local authority to determine liability. Naturally, if informed by an owner that an otherwise liable property has been uninhabitable, a local authority should require evidence demonstrating the condition of the property and the relevant liability dates for the charge. Should a local authority satisfy itself that a property was uninhabitable, it is open to that authority to provide written confirmation to the property's owner stating that no non-principal private residence charge liability is outstanding in connection with that property. First, to clarify the situation, I don't know what the individual case that Senator Daly is referring to, but maybe he might want to enlist my support for to have a look at it.
Well, I think the Minister's support will be more than welcome on the particular issue, and I'm sure that maybe he'd be able to persuade the local authority in Kerry to issue the certificates. And as I understand it, there's no reason why they can't do it in advance of a sale. So if someone went looking for the discharge and to prove or to show that they're not, that they're looking for an exemption, that the local authority can do so regardless of whether or not the property is sold. Would that be your reading of it, Minister?
Maybe it's a minute.
Thank you, Minister.